Mateo. Department 119 is now in session. Judge Tomczak presiding. Please come to order and turn off all cell phones and refrain from talking.
Thank you, Bailiff. Everybody hear me okay? Excellent. You can be seated. Well, hello. Welcome. Welcome to our participants. Welcome to their families and other guests watching at home to our first ever mock trial showcase here at Notre Dame Belmont. I am Mr. Tomczak. I'm the mock trial coach here at Notre Dame, and I am your judge for this evening. I know I should be wearing a robe. As it turns out, I blew my entire wardrobe budget on the nice shiny gavel. So, what can you do? What you're going to be experiencing tonight is an accurate representation of a mock trial competition. In terms of structure and format, you're going to be seeing what our students do when they go to the Redwood City Courthouse every year and compete against other schools. For those of you at home, these students have been working diligently on this case since they first received it in September. And fun bit of trivia for you, almost without exception tonight, almost every performer you're going to be seeing are in fact mock trial rookies, just finishing up their first mock trial season. And I am very proud of how far they have come, personally speaking. Just a couple of preliminary matters before we get into the event itself. There's a long list of people who made tonight possible. I'm going to save those credits for the end. There's going to be kind of a natural pause where I can do that, so I'll hold off on that. I did want to mention for you at home our Mock Trial Basics summer school course that we have at Notre Dame. If you're coming to Notre Dame or you're interested in mock trial, even if you've been at Notre Dame, you haven't done it yet, we do a 2-week course every summer. We do direct examinations, cross-examinations, objections, all of that fun mock trial stuff. I think it's pretty great. You can sign up for that pretty much anywhere you sign up for Notre Dame summer school stuff. I know there's a link on our website. So I would encourage you to sign up. It's a lot of fun, and I look forward to doing it again this July. This is a live broadcast. So we are trying to bring you at home as much as we can into the courtroom here. That being said, technology often has a mind of its own, and we are at the whims of the Wi-Fi gods as much as anyone. So if for some reason there is a technical issue, we do beg your pardon and patience. If you have to lower your volume for some speakers, raise them for others, we apologize for that. That's kind of the nature of the beast. And if for some reason the broadcast does cut out entirely, hope not, we are recording the file locally, and we'll make sure that that video gets uploaded so that you at home can watch the whole thing in full at some point in the future. Now, that being said, if you do stick with us the whole night, if you are able to watch the whole thing, we will be at the very end asking you what you think should happen to our defendant, Jamie Cobey. Should they be convicted or should they be acquitted? So stay with us, weigh the evidence as it's presented to you, pay attention to detail, and you're going to be part of our unofficial virtual jury. So that's lots of fun. I think the only other note I have is for the performers themselves, and it's to simply say this: have fun tonight. You've done the hard part. You've done the prep. This is all about getting to bring it all together and enjoying the full experience, okay? So, rule number 1 in my courtroom: have fun. Because if you're not having fun, you're not getting the full mock trial experience, and that's no good. I think we can do that. Okay, with all of that said and done, I think we can officially call this court into order. Oh, that's fun. Okay, the gavel was the right decision. Who needs a rope? And if we could have a member of our production crew give a microphone to the prosecution so that both teams can introduce themselves and we can get this underway. There you go.
Good evening, Your Honor. My name is Kira McDonald. Devitt, and tonight I'll be arguing the pretrial motion on behalf of the people of the state of California. With the court's permission, may my co-counsels please introduce themselves?
Yes, please.
Good evening, Your Honor. Maggie Templeton for the people of the state of California.
Good evening, Your Honor. Bella Swanberg for the people of the state of California.
Good evening, Your Honor. Claire McCoy for the people of the state of California. With the court's permission, may my witnesses please introduce themselves.
Absolutely. Thank you, counsel.
Good evening, Your Honor. My name is Trisha Garud, and tonight I am Dr. Charlie Dunn.
Good evening, Your Honor. My name is Eva Benson, and tonight I am Deputy Sheriff Cody Garrett.
Good evening, Your Honor. My name is Bella Taylor, and tonight I am Terry Edwards.
Good evening, Your Honor. My name is Sophia Rask, and tonight I am Angel Russell. With the court's permission, may the timekeeper please introduce herself.
Absolutely. To save you a couple steps, if we could have a production crew get her the mic, please. Thank you.
Good evening, Your Honor. My name is Christine Nexmander, and tonight I will be your courtroom clerk. I will be using the visual signals of 2 minutes, 1 minute, 30 seconds, and stop, as well as an announcing when the time is over.
Thank you very much. All right. If the defense could introduce themselves now. Thank you.
Good evening, Your Honor. My name is Bronwyn Pigeon, and tonight I will be arguing the pretrial motion on behalf of the defendant, Jamie Cobey. With the court's permission, may my co-counsel please introduce himself.
Of course, counsel. Thank you.
Good evening, Your Honor. Mallory Moore, representing Jamie Cobey.
Good evening, Your Honor. Amanda Tam, representing Jamie Cobey.
Good evening, Your Honor. Perry Stevick, representing Jamie Cobey. May our witnesses please introduce themselves?
Absolutely. Thank you, counsel.
Good evening, Your Honor. My name is Genevieve Lamb, and tonight I am Dr. Tyler Lamb.
Good evening, Your Honor. My name is Sienna Keebler, and tonight I am Francis Yazzie.
Good evening, Your Honor. My name is Megan Gomez, and tonight I am Danny Emling.
Good evening, Your Honor. My name is Caitlin Reynolds, and tonight I am Jamie Cobey. With the courtroom permission, may we now introduce the bailiff.
Absolutely. Get the mic to you in a moment.
Good evening, Your Honor. My name is Sophia Gomez, and tonight I am your bailiff. Would you like me to go over the rules of the court to the parties present?
You know, I would please. Thank you, bailiff.
The rules are as follows. Please keep your cell phones turned off or on silent. If you need to take a call, please exit the courtroom when between witness statements. Please no food or drinks are allowed with the exception of water, and please keep your mask on over your nose at all times.
I think we made an exception to that last rule when you are actively speaking. All right, thank you. Yeah, so if we could, I'll take the microphone right there, and I will take that. And then Kaylee, hang on. If you could hand that back to Kira, and if you could hand this one to Bronwyn, they can get mic'd up for pretrial. You need a laugh. That's right. Here you go. Oops. There it is. All right, are you ready, counsel?
Yes.
All right, I understand the defense has brought a 504 motion or a motion to exclude evidence before this court. You may present your argument.
Good evening, Your Honor. And if it pleases the court, the defense respectfully requests that an exhibit of evidence be removed from the preceding trial due to a violation of the defendant Jamie Cobey's Fourth Amendment rights. This motion rests on two major arguments. The first is that the photo was taken
It's okay. Keep going.
in a picture in Jamie Cobey's curtilage, and the duration and the intent makes it a violation of their Fourth Amendment rights. The Jamie Cobey and Eric Smith, who is the victim in this case, were neighbors for years, and Eric was Jamie's landlord. However, they had several arguments over various things, and they never really got along. Now, after one particular incident, the deputy sheriff gave Eric a camera, smart camera, that would film Jamie Cobey's backyard and directly sent the footage to an iCloud drive shared with the sheriff's department. Now, 7 months later, the sheriff reviewed this footage for this case and found this evidence.
So, counsel, just to clarify, pardon the interruption, this camera was actively recording for 6.5, 7 months,
Yes.
collecting evidence that whole time.
Yes.
Okay, thank you. Please proceed.
Now, Jamie Cobey actively said she did not like this, and they were actively against this camera, and this was their curtilage. Now, curtilage is overall defined by 4 major points. The first is this directly connected to this house? The second is the proximity. The third is the nature, and the fourth is the steps taken to protect that curtilage.
Now, that criteria you mentioned, is that coming from a specific precedent case?
Yes, it is coming from U.S. v. Dunn.
Okay, so that's the Dunn test, those 4. Got it.
Okay, so Jamie Cobey's yard, I believe, follows 3 of these, which is enough for it to be considered a curtilage. So it was directly attached to his house, surrounded by a 6-foot wooden fence, albeit with a chain link gate, and it was used for things like gardening and just overall as a backyard that most people would consider private. Now, that camera was still filming this. Jamie Cobey, again, said he did not like this and he felt this was an invasion of her privacy. Now, the other thing is the duration. The duration of the camera was for 7 months looking in. Now, this is not just like, oh, that they happened to take a picture. This is they spent 7 months filming her backyard, even though she said she did not want it, which, as Eric Smith is an agent of the law in this case, would require a warrant.
How many times did Miss Cobey object to the camera having a view of her backyard?
She only objected once, but I still feel that is more than enough to say that she did not want it there. If you object to something once and then don't change your opinion is still, I do not want this here.
Okay. Now, let's say for sake of argument that I rule how you want me to, that Jamie's backyard is curtilage to her home. It's part of the property of the home. Does that automatically grant that backyard an expectation of privacy, in your opinion?
Not necessarily. However, I feel that is irrelevant because they are both here in this case. Because she did have a 6-foot wooden fence around her backyard, and it was like overall somewhere where someone would feel like they had curtilage.
But the gate wasn't wooden, right? The gate was, as I recall in the record, this chain link that anybody could see through.
Yes, and this is where duration comes in, because while someone glancing in would have been okay, this is the equivalent of someone standing outside of that chain link fence, staring in for 7 months, which I would personally consider extremely creepy and a violation of my privacy.
I think a lot of people would, yeah.
Yes, so while the inherent, this picture could feasibly be taken without a warrant, the duration of this camera being up and the fact that it is not a picture, it's a clip from a video that was up for 7 months, is what makes it a violation of the privacy.
I'm going to ask you a hypothetical question. I think in this case, Mr. Smith's property and Ms. Cobey's property were next to each other on the same rough elevation of land, right? Now, if Mr. Smith's home had been on a hill and looking down could see into Ms. Cobey's backyard, would there still be an expectation of privacy there?
I think there would have been less, though this camera would still, if it was up for 7 months, would be a violation. However, that is not relevant because they were on land and Mr. Smith had to put it on a pole to look down.
That's why I asked, because the camera was highly elevated, right? It
Yes.
wasn't like along the fence line or something. Okay. Thank you. Continue if you have more.
Okay, so the last point is that one of the things which has come up in this case is that it wasn't necessarily inside the yard. This was not an intrusion into Ms. Cobey's yard. However, that does not have to be in place for it to be a violation of privacy. In US v. Kylo, it was a thermal imaging device attached to the outside of their property, but it was still considered to be a violation of their privacy.
Now that thermal imaging device, that could see the heat signatures from within the home itself.
Yeah, yes, with the home in the backyard.
Okay. So is it your argument that the same protection that you'd have behind the walls of your home exist behind the fence in your backyard?
I would say there's a similar for this duration of time.
Okay. Please proceed.
Okay, so for this reason, Your Honor, the defense respectfully requests that this exhibit of evidence be removed from the proceeding trial because it violates Jamie Cobey's Fourth Amendment rights.
Okay. Thank you, counsel. You can be seated till your rebuttal. I assume the state would like to respond to the defense's motion.
Yes, I would.
Please
Your Honor.
proceed.
Once again, for scoring purposes, my name is Kira McDevitt. May it please the court that the state requests that you deny the defense's motion and allow Exhibit A, the image of the snake tongs, to be admitted as evidence. The camera and images did not violate the defendant's Fourth Amendment rights. The main points of our argument are that the defendant's backyard was not curtilage, the sign specifically acknowledging the camera, and that the defendant did not show a reasonable expectation of privacy. To start on, the defendant's backyard was not curtilage. On October 10, 2020, Deputy Sheriff Tony Garrett gave Mr. Eric Smith a free smart camera, which was also available for public purchase. The camera was placed on a 10-foot yard, which was directed towards the defendant's backyard. The camera's use was for a surveillance device because Mr. Smith had suspected the defendant of breaking into his own home. In US v. Dunn, the court established a 4-part test determining the issues of curtilage. 2 parts of this test were whether the area itself was enclosed and the steps taken by the resident to protect the area from people passing by. In the case at bar, those 2 parts were not fulfilled. The defendant's backyard was not enclosed and the defendant took no steps to protect their land from people passing by.
When you say enclosed, just to be specific, do you mean enclosed along the perimeter, or do you mean enclosed in that there wasn't like a dome or some sort of cover over it?
I mean enclosed around the perimeter.
Okay, because in this case, there was a gate, but I think the record indicated the gate didn't have a lock on it.
Yes.
Okay. My second question relates to US v. Dunn. Opposing counsel made the point that at least 3 of the 4 criteria in the Dunn test apply to Ms. Cobey's backyard. You're contending that only 2 of those criteria apply.
I would say all 4 have to apply. My point was that 2 of the criteria was not fulfilled.
Okay, so in order to rule something as curtilage, your argument is all 4 parts of the Dunn test have to be met.
Yes.
Okay. What about, I believe it's US v. Romero Bustamante, where law enforcement went into the defendant's backyard in order to find undocumented immigrants that jumped the border fence. And in that case, I believe the defendant's backyard was similarly not enclosed, and so wouldn't meet all 4 parts of the Dunn test. And yet, the court ruled for the defense there. Can you distinguish this case from Romero Bustamante?
Yes, Your Honor. In the case at bar, the snake tongs could have clearly been seen through that chain link gate fence. But in the case of Romero Bustamante, the immigrants were completely hidden. The officers had to hop the fence to see the immigrants. They were completely hidden and couldn't be seen by anyone standing outside of that fence.
Okay, so in this case, if Eric Smith or the sheriff's deputies had gone onto the backyard and seen the snake tongs, you'd maybe argue something different. But
Yes.
since it was just a camera from a remote view, it's okay.
Yes.
It's distinguishable at least.
Yes.
Okay, please proceed.
The defendant did not take any steps to protect their own property. They never covered up the chain link fence gate, and they never increased the height of their wooden fence. The Fourth Amendment protects people's land and curtilage, but as said before, the defendant's backyard was not curtilage, making the images not in violation of the defendant's Fourth Amendment rights.
Now, the defendant was renting this property from Mr. Smith, right?
Yes.
So they couldn't just automatically build their own fence, right? I'm sure there are hoops they'd have to jump through. Should that factor in at all in our analysis?
Well, I'm sure the defendant could have also asked the person they were renting the property from if they could have taken any measures to protect their property if they believed the camera was intruding in their personal property, which is actually my second point, if you'll let me proceed.
Proceed.
Secondly, in U.S. v. Jones, it is quoted on page 26 that a Fourth Amendment search occurs when the government violates a subjective expectation of privacy that society recognizes as reasonable. In the case at bar, the defendant's backyard gate was 4 feet tall and made out of chain link material. Anyone could see over the fence and see the snake tongs in the defendant's backyard. In addition, the defendant's backyard bordered a public state park, meaning that anyone could access their backyard and see the snake tongs. For these reasons, the defendant did not have a reasonable expectation of privacy that society recognizes as reasonable.
Do you recall, I'm sorry if you said this earlier, do you recall how tall the fence was?
It was 4 feet tall.
Oh, it was only 4 feet tall. Oh, okay.
May I proceed?
You may.
Lastly, near the camera, there was a sign that stated, "Smile, you're on camera." The defendant acknowledged the sign, but then later forgot it was even there. He stated in his statement on page 42, line 32, "After a while, I forgot the sign was even there." If the camera was so intrusive in their property, wouldn't they have done more to protect it? In the case of California v. Serralo, the observations made by the plane were non-intrusive. The court also ruled that any member of the public flying in that public airspace could have seen what the police officers observed.
Serralo was the case where the police chartered a private plane to fly over the defendant's property and saw the illegal drugs there, correct?
Yes, Your Honor.
I guess my question then gets to one of duration, because as defense counsel pointed out, this camera was up for 6.5 months or so. So it really wasn't similar to a plane flying over. It'd be like a helicopter hovering there for 6.5 months taking pictures. Doesn't that seem a little, I don't know, Fourth Amendment violation-y?
Well, I would say that the defendant only asked once, and it's not really the duration, it's the fact that the defendant forgot that the camera was even there. If the defendant believed that the camera was intruding on their personal property, I can't speak for other people, but me personally, I would have done more to protect my property.
So what if, following the logic of that, and I know what your answer is going to be, but following the logic of that, could the police knock on someone's door, ask to come in, get rejected, and then 6 months later come in anyway, hoping that they forgot?
I'm not exactly sure what you're asking. Can you please restate the question?
I guess my question is, how many times over how much period of time do you have to object in order for your Fourth Amendment rights to be, to stick?
Well, back to my same point, I feel like more than once, forgetting it, that it was there, I feel like more than once is definitely not enough.
Okay, you may proceed. Thank you.
Okay. In the present case, any member of the public walking through that public state park could have seen the snake tongs just as easily as the camera did. The camera was just as a precaution because Smith feared for his life. As said before, if any member of the public, if they believed that the camera was intruding in their property, they would have done more to protect it. In conclusion, Your Honor, the Fourth Amendment does not protect unreasonable searches. The camera's intent was to be a surveillance device, not a search, because Smith suspected the defendant of breaking into his own home. The camera was never meant to be a search. And if the camera was so intrusive in the defendant's property, he would have made more of an effort to protect it, which therefore he didn't show a reasonable expectation of privacy. And lastly, the camera didn't show anything that couldn't have been seen by anyone walking by in that public state park. For these reasons, the prosecution requests that you deny the defense's motion and allow Exhibit A, the image of the snake tongs, to be admitted as evidence. Thank you.
Thank you, counsel. I believe both sides get to rebut the other's position. So, defense, if you would like to rebut away.
Alright, so here's the thing. A lot of the stuff said in that was just, respectfully, kind of wrong. Because it says openly in the case file that Smith was an agent of the law and the camera was given to him by a deputy sheriff to gather incriminating evidence on Ms. Cody. Now, I also believe that the fact that she only objected once, and even that she forgot about it, does not go again. Automatically say she no longer has Fourth Amendment rights. As you said, if someone comes up to your house and says, even if there's says, can I come in? You say no, and they put a sign that says, can I come in outside my house? I'm probably it's gonna blend into the landscape after a while, but that doesn't mean 6 months later they can come into my house. That's not how that works. And second of all, with Cirillo, the camera that would be like, as I said, someone putting the camera or having a helicopter flying over their yard. That's not something that feels like it should be allowed. That's not just like, this is not an argument over that one piece of evidence. Now, the last thing, really, I have to say is that the fence was 6 feet tall, and even if the gate was 4 feet tall, and so I would not feel like someone in that state park should be allowed to look in my yard. Because if there's a 6-foot fence, I would not feel like someone should be allowed more than a glance into my yard. And this was for 7 months. So that just does not feel like this is with someone's rights under the Fourth Amendment.
Thank you, counsel. Quick question before I let you go. Under your opinion, is the privacy that we have in our backyards absolute? Is it like, it's my backyard, nobody gets to look in, nobody gets to use any evidence of what they see there? Or is there some limit to your privacy in the backyard?
I think a quick glance, especially in the kitchen, would be fine, but it's the fact that this was for, almost 7 months, and constant, and that just feels like it's completely overkill, and this is not something we should be doing,
Okay. Thank you, counsel, very much. You can take your seat. And rebuttal from the state.
May I proceed?
You may.
The defense made some interesting points, but I would like to point out a couple flaws. First of all, the defense even said in their statement that the camera wasn't intruding in the defendant's personal property. So they said it themselves. The camera wasn't intrusive. It didn't violate their Fourth Amendment rights. Secondly, they also mentioned that the defendant only asked once. And I would like to bring back to my first point that asking only once and then forgetting about it is not right, because if they believed it was intruding on their personal property, I for certain definitely wouldn't have not forgotten about it if it was up for as long as the defense said. And third and lastly, the defense also said that the defendant did not have a reasonable expectation of privacy. But I would like to bring up the case of Katz v. US, and it is stated in the casebook that objects in plain view of outsiders are not protected because no intention to keep them hidden has been exhibited. In the present case, the chain link fence gate was not covered up. So anyone walking through that public state park could have seen the snake tongs, as I said before. For these reasons, the prosecution requests you deny the defense's motion and allow Exhibit A, the image of the snake tongs, to be admitted as evidence.
Thank you, counsel. All right. Before I issue a ruling, well done, both of you. It is not easy to be one-on-one with the judge who is interrogating you about the finer points of Fourth Amendment law. So give yourselves some credit. You had creative and compelling arguments, both of you. You answered questions extraordinarily well. Let me also remind you that neither my ruling my ruling doesn't affect your scores. Let me say that. Your scores are entirely dependent on your presentation and how well you responded to the questions. My ruling doesn't affect that. So there isn't a winner from a point standpoint, even if I rule against you. So no, exceptionally well done. Now to the matter at hand, because unfortunately I do have to rule one way or the other. Part of what makes this challenging is there are several overlapping issues here. Was Miss Cobey's backyard curtilage? I think it's pretty clear under the Dunn test that it was. I think most people would consider a backyard a part of their home, especially one immediately next to and enclosed around the home, just as you would a front porch or another fenced off area right next to, adjacent to the home. That doesn't necessarily grant it automatic Fourth Amendment protection, however. The courts have said in past cases that you need to have a subjective expectation of privacy, and that expectation has to be reasonable by society. Was there a subjective expectation of privacy here? Again, I think it's clear that there was. Ms. Cobey did object to the presence of the camera. I would feel very uneasy about putting a specific number on how many times you have to say something in order to have your Fourth Amendment rights suddenly be valid. So, yes, she had an expectation of privacy subjectively. Was it reasonable? That's a tougher question. The gate was unlocked. The gate was made of chain link, and there is nothing in the record to indicate that Ms. Cobey did anything to obstruct the view into her backyard. No umbrellas were put up, no tarps, no blanket put over the gate, none of that. Now, to the defense's point, the idea that the police can unofficially deputize someone, give them a camera, and have them over a period of 6.5 to 7 months intermittently collect evidence that could eventually be used against them is troubling and worth Fourth Amendment scrutiny. However, I don't know that we even get to that point in this case. Deputy Garrett, in her statement, says that the purpose of the camera was not to look onto Miss Cobey's property, but to see if anybody was coming onto Mr. Smith's. In every case both sides cited tonight, the police intended to look into or go onto the defendant's property to collect evidence. We don't have that in the record here. Yes, the camera could see into Miss Cobey's backyard, but that appears to be incidental, almost accidental. The Fourth Amendment protects against unreasonable searches and seizures, and if there's no intent to gather evidence, it's hard to say that a search took place. So, on that very minor technicality, I'm going to deny the defense's motion and allow Exhibit A to be used at trial if the prosecution chooses to do so. But again, that has no bearing on your scores. It also has no bearing on how good your arguments were. It's just my understanding of the facts as they must match the law. But no, well done. All right, let's give both sides a moment to rearrange for trial. Let's get the attorneys at the counsel table. Let's get the defendant at the counsel table. And remember, you're still on the microphone.
That was stressful.
No, you can.
Can I sit there? Thank you. Oh, yeah.
All right, looks like both sides have their transmitters. Are both sides ready to proceed? Almost. They're almost ready to proceed. Shall we get into opening statements, prosecution?
Your Honor, before proceeding with opening, prosecution would like to address preliminary matters.
Go for it.
So first, we would like to request permission to move about the well between the counsel table and the witness stand.
Well, since you're already in the well, I better grant you permission, otherwise the bailiff has to tackle you. So, permission granted.
The people have brought up one exhibit, and this is an image of Eric Smith's mailbox, and we request that it be marked as Exhibit B for identification purposes.
Okay, it'll be marked. It's not moved into evidence yet, but that'll come, I assume.
And lastly, Your Honor, we would like to make note of the most recent errata dated January 10th.
So noted.
May I proceed with opening?
You may, counsel. And just as a reminder to everybody as we're getting going here, remember to project, not just to fill the space, but also so that the microphones pick you up at home. All right, good to go, counsel.
The day is April 29, 2021. Mr. Eric Smith is going to get his mail. As he opens his mailbox and reaches inside, a rattlesnake leaps out and bites him on the wrist. Mr. Smith was found dead in his front yard the next day. So why was that snake in that mailbox on that day? How did it get there? Tonight, the evidence will show beyond a reasonable doubt that it was placed there on purpose by someone with the intent of killing Eric Smith. Someone who had been brought to the brink and pushed one more time. The people will show that that is the defendant, Jamie Cobey. For the last decade, Miss Cobey's life had been dominated by two things. One of them was taking care of her chronically ill mother, and the other was dealing with a very difficult landlord, Eric Smith. Mr. Smith was known to harass the Cobeys with loud music in the early mornings. He would destroy Miss Cobey's most prized succulents, and most cruelly, he would turn off the Cobeys' water and power even if the bills were barely late. This would reach us to a fateful conclusion on April 22, 2021, when Mrs. Cobey's oxygen machine was shut off from lack of power and she died from cardiac arrest. Where Miss Cobey had taken all of this from Eric Smith to the best as she could, her mother's death brought her to the brink. And on the day of Mrs. Cobey's funeral, Mr. Smith would push one more time. Rather than take responsibility in his role of Mrs. Cobey's death, Mr. Smith would blame the dutiful daughter. And after this encounter, Miss Cobey would go home, find a Mojave rattlesnake. She would silence the snake by cutting off its rattle and placing it into Mr. Smith's mailbox. Miss Cobey was seen at Mr. Smith's mailbox that day that he was bitten with an animal trap, a point that Miss Cobey cannot and will not deny. You will hear from Deputy Sheriff Garrett how Miss Cobey had all the right tools and gears of handling venomous snakes. You will hear how Miss Cobey knew of Eric Smith's health conditions that, according to Dr. Charlie Dunn, the medical examiner, only made the bite more dangerous. And you will hear how Miss Cobey yelled into the late desert night, "I am going to kill him." Your Honor, Miss Cobey had been brought to the brink by Eric Smith and was pushed one more time. She considered her actions and made a simple choice. Miss Cobey had the motive, the intent, and the capability of causing the death of Eric Smith. And by the time all of the evidence has been heard, and as my colleague rises for closing, we will have met our burden of proof beyond a reasonable doubt for all elements under Cal Crimes 520, 521, and 570, and we will request a verdict on guilty for first-degree murder or an other more related offense, voluntary manslaughter. Thank you.
Thank you, counsel. Would the defense like to do their opening statement now or defer until after the prosecution has rested their case?
Now, Your Honor.
Then you may proceed when ready.
On April 29, 2021, Eric Smith was bitten by a Mojave rattlesnake. A freak accident of nature. But tonight, the prosecution is hoping to provide reason and order behind this tragic death by placing the blame on Jamie Cobey. You will see through our case tonight that Jamie had nothing to do with Mr. Smith's death. There is no proof beyond a reasonable doubt otherwise. You will see the prosecution finding evidence she could have placed the snake, yet no evidence she actually did. Because in reality, access is not the same as use, and grief is not the same as vengeance. Under Cal Crim 520, the prosecution must prove two things beyond a reasonable doubt: action and intent. You will see them show that she could have placed a snake, but they must prove she actually did. There, however, is no way to place this burden on her. They also must show that she intended to kill Eric Smith, not that she might have intended to. There is no evidence to this claim either. The prosecution have taken Jamie's grief and twisted it into a want for vengeance that simply does not exist. You will see that her grief is simply that: grief. We will hear from 4 witnesses tonight: Dr. Tyler Blake, a herpetologist and the only snake expert involved in this case, will talk about the behavior of snakes. She will share how the snake could have easily gone into the mailbox, why the rattle coming off is actually quite common in nature, and why the snake in this case behaved in the way it did. In speaking with Frances Yazzie and Danny Ellen, who both know Jamie well, we will learn of her forgiving and apologetic nature that would not allow her to act in the way the prosecution has suggested. In speaking with Jamie, it will be evident she is a kind-hearted landscaper with a love for animals that would not allow her to harm another's soul. Tonight, my co-counsel and I will show that Jamie had no harmful intention in her heart. The prosecution is just hoping to provide reason behind this accident of nature. They can show she had access, but not use. They can show her grief, but not vengeance. Through our witnesses' testimonies, and by the time Ms. Stevick has made our closing arguments, we will prove to the court that Jamie is innocent. Your Honor, tonight the defense will ask that you find Jamie Cobey not guilty on the charge of first-degree murder and voluntary manslaughter. Thank you.
Thank you, counsel. All right, is the prosecution ready to call its first witness?
Yes, Your Honor.
You may do so.
Your Honor, the prosecution calls Dr. Charlie Dunn to the stand. I didn't know I was supposed to do that.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform with the facts and rules of the Mojave Composition? I do. You may proceed.
And for our people at home who may not know you as well as I do, could you just every time you get up state your names again so that people get to know you? So that was Bella Swanberg who did the prosecution opening, that was Mallory Moore who did the defense opening, and now we have...
For scoring purposes, my name is Claire McCoy.
And for scoring purposes, my name is Trisha Garud.
Proceed when ready, counsel.
Good evening. Please state your name and occupation for the court.
Good evening. My name is Dr. Charlie Dunn, and I've been the Chief Medical Examiner for Burnsley County since 2015.
Could you please briefly describe your academic
Background?
Of course, I have a bachelor's degree in biology, and I attended graduate medical school, and I completed my residency and fellowship specializing in clinical and forensic toxicology.
Do you have any experience with venomous or poisonous animals?
Yes, during the fellowship I just mentioned, I was able to familiarize myself with such animals. And also, as I've lived in the desert all my life, I do have a particular interest in the toxins of desert animals.
Thank you, Doctor. How did you become involved in this case?
I performed the postmortem of the victim, and I visually examined the rattlesnake that bit him.
And from your autopsy on Smith, were you able to determine the time of death?
Yes, based on the victim's body temperature measured during intake at the hospital, and of course the stage of progression of rigor mortis, I've approximated the time of death to be likely between 3 and 6 a.m. on April 30th.
And were you able to determine the cause of death?
Yes, the cause of death was kidney and heart failure as a result of acute tubular necrosis and epicardial hemorrhaging following lethal envenomation.
I'm sorry, Doctor. Could you please clarify that for the court?
The snake bit him and he died.
Thank you, Doctor. Have you seen a death like Smith's before?
During the course of my career, I believe I've seen one other death from a lethal venomous snake bite.
And on Smith's body, did you find any physical evidence of a snake bite?
Yes, on the victim's left wrist were 2 puncture wounds surrounded by red swollen skin, and that is consistent with the snake bite.
Doctor, what is the effect of a Mojave rattlesnake's venom on a human victim after a bite?
Well, most victims don't typically experience anything drastic since antivenom is so widely available. But the venom is both neurotoxic and hemotoxic.
You mentioned neurotoxic venom. Could you please explain what the neurotoxic venom does, the effect that the neurotoxins have on the victim?
Yes, the neurotoxins, by the way, those are toxins that attack the nervous and respiratory systems. Those cause the victim to undergo periods of unconsciousness and paralysis.
And what effects do the hemotoxins have on the victim?
Your Honor, relevance. We already know, she's already clarified why Mr. Smith died. I don't see what the neurotoxins and hemotoxins have to do with that.
Your Honor, may I respond?
You may.
By clarifying what the hemotoxins and the neurotoxins and the effect that they have on the victim's body, our expert witness will be able to determine the effect that the venom had on this body specifically. It's just for clarification.
Any response?
Just what I previously said, that we already know how the snake bit him, and she's already clarified what neurotoxins do. Adding on the hemotoxins, I don't really see what that has to do with it.
Given that it's the expert witness and I want to know, I'm going to overrule the objection, but well done. You may answer the question.
Would you like me to repeat the question?
Yes, please.
What effects did the
Hemotoxins have on the victim.
Well, the hemotoxins kill red blood cells and essentially hinder the blood's ability to deliver oxygen needed for cellular respiration. And below normal oxygen levels can impede both brain and heart function. Epicardial hemorrhaging is another byproduct of the hemotoxins, as is thrombocytopenia.
Are those
Effects usually sudden.
Well, we have to consider that snake venom was designed for prey, and normal human bodies are considerably larger than that of a mouse or a rabbit, let's say, so symptoms do take longer to appear. And until then, the victim would feel perfectly all right, barring the local pain from the bite, of course.
Dr. Dunn, what's the likelihood of survival from a Mojave rattlesnake bite?
Well, this snake's venom is 16 times more potent than that of any other rattlesnake, so victims would definitely die without proper immediate intervention.
Interventions such as what?
Well, administering antivenom would be best. Antivenom binds to and neutralizes the venom, halting further damage, but it can't reverse anything that's already done. So victims should seek out medical attention as soon as possible. I mean, ideally the antivenom would be right next door, but that's not always the case.
Thank you,
Doctor, one last question. In your expert opinion, what do you believe the effect, what was the effect that the Mojave rattlesnake's venom had on Mr. Smith?
Well, because the victim chose not to receive immediate medical attention, he was dead when the snake bit him. His body simply didn't know that until hours after the bite.
Thank you,
Dr. Dunn, Your Honor, no further questions. May my witness please be excused?
Well, we got to do cross-examination first. Unless the defense doesn't want to cross-examine.
No, Your Honor, the defense is allowed to walk.
Okay, then she'll stay up there for a minute. But
May I proceed, Your Honor?
when ready, yes.
Once again, my name is Mallory Moore. Doctor, Mojave rattlesnakes have been known to get into mailboxes, haven't they?
Well, they do typically seek out more accessible places when it's hot outside, like under a rock, for example, but yes, I suppose it's possible that they might choose a mailbox.
And rattlesnake rattles do come off on their own in the wild, don't they?
It takes quite a great deal of force, so it's quite rare. It's not a common occurrence at all.
Is that a yes?
It's a yes, but not often.
Doctor, are you aware that 4 or 5 rattlesnake rattles were found in a tub in Jamie's home?
I am, but I wouldn't say that makes the event any less rare. Just because there was a collection doesn't mean a rattle coming off is rare.
All of this, where snakes go, how the rattles come off. All this is about snake behavior. You didn't specifically study snake behavior in school, did you?
I never formally studied it, but that doesn't mean I don't have any knowledge on it, I do have some reasonable extent of knowledge, as I've lived in the desert all my life.
Doctor, you never completed a fellowship studying snake behavior, did you?
No, that was in forensic toxicology, but during my fellowship I was able to familiarize myself with venomous and poisonous animals, such as
Doctor,
snakes.
You do not have any experience at a zoo or reptile sanctuary, do you?
No, I've never worked at one.
In fact, you have never even owned a snake as a pet, have you?
I've never had a pet, but I live in the desert, as I've said before, so I am surrounded by snakes every day.
Doctor, the fellowship where you earlier mentioned venomous animals. That was specifically to study forensic toxicology, not snake behavior, correct?
Yes, but again, during my fellowship, I did familiarize myself with venomous and
Thank
poisonous.
you. No further questions.
Thank you, counsel. Any redirect?
No redirect, Your Honor.
Now, do you want to excuse your witness?
Yes, please. May my witness please be excused?
Absolutely. Step down, doctor. Thank you very much. Does the prosecution have any other witnesses to call?
Your Honor, prosecution calls Deputy Sheriff Garrett to the stand.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform with the facts and rules of the mock trial competition?
I do.
You may be seated.
For scoring purposes, my name is Bella Swanberg.
For scoring purposes, my name is Eva Benson.
And for the convenience of the court, this witness's testimony can be found on page 33 of the case packet.
Ooh, that is convenient. Thank you.
Good evening.
Good evening.
Please state your name and occupation for the court.
My name is Tony Garrett, and I have been a deputy sheriff with the department for 20 years here in Burnsley, ma'am.
What, if any, involvement do you have in the case at hand?
On April 30th, 2021, at approximately 8:40 a.m., I responded to a call reporting a 1054, or a possible fatality. An older man's body found at 46601 Raptor Road.
In what state did you find the body?
The body was face down. I was unable to find a pulse and observed the distinctive puncture marks on the man's left wrist.
Were you able to identify the man found at the scene?
I was. I recognized the deceased as the owner of the home, Eric Smith. I'd responded to several disturbance calls over the years, and I knew him on site.
And what were these calls typically about?
Various nuisance allegations. Mrs. Cobey would complain Smith's music was too loud, while Smith would complain Cobey was blocking their driveway. On 2 separate occasions, Mr. Smith would complain that Miss Cobey left animal feces on his doorstep.
Thank you for explaining, Deputy. Now let's return back to the crime scene. Who else, if anyone, did you find at the scene?
I found a line worker, Angel Russell, standing to Smith's face-down body. Miss Russell also mentioned that she witnessed Mr. Smith get bitten by the snake that came out of the mailbox, of his mailbox.
This is hearsay. There's no way Deputy Eric can say know what Ms. Russell said.
Your Honor, may I respond?
Yes, please.
Since my witness is a deputy sheriff, this falls under the hearsay exception of legal document under public employee.
No response, Your Honor.
Okay, I guess I'll overrule the objection. You may proceed, counsel.
Turning to Exhibit B on page 55, do you recognize what this exhibit is?
Yes, it is a photo I took of Eric Smith's mailbox.
And is this a fair and accurate representation of this item?
Yes, ma'am, it is.
Your Honor, we ask that Exhibit B be moved into evidence.
Sure, could you hold up the larger version just so people at home can see what the heck we're talking about? There it is, that's a mailbox. Any objection by the defense for admitting this evidence?
No, Your Honor.
The evidence shall be admitted. Thank you, counsel. You may proceed.
So, Deputy, regarding this mailbox, what, if any, notable observations did you make of it?
I noticed that the mailbox was located up on a post, which struck me as odd because how did the snake get in there? I lifted latent fingerprints and took photos for evidence. Later, the fingerprints matched Jamie Cobey's in a forensic report.
Thank you for explaining. And after your initial observations, what was your next course of action?
I went over to Cobey and asked if she had seen or heard anything relating to Smith the day prior.
What was their response?
Cobey said no. She said she was still grieving over the death of her mother. She also mentioned that the day Mr. Smith was bitten, she dropped off some rent money in the mailbox. However, I never found it in the mailbox or in the deceased's house.
And who else besides Cobey did you interview?
I interviewed Mrs. Russell, as well as Terry Edwards, Francis Yazzie, and Danny Emling. Mrs. Edwards also mentioned that she witnessed a heated argument between Mrs. Cobey and Mr. Smith at Jamie's mother's funeral.
Thank you. And what did you decide to do next?
I decided to go to Cobey's residence to ask some questions. She appeared very nervous, and she said she was very busy. She even asked if she could stop the interview. However, she did give me permission to examine her residence.
And was there anything in Miss Cobey's residence that stood out to you?
In her living room, there was a couple books about venomous snakes. There was a shelf with a small tub on it that had what appeared to be 5 rattlesnake rattles in it. And next to that tub was a small vial of liquid which had a handwritten label on it saying anti-venom.
Did you find anything else?
I also observed a pair of animal handling gloves, a long sleeve shirt, and what appeared to be thick-skinned boots. Miss Cobey mentioned that they were snake-proof boots. I also noted a large canvas tool bag.
Thank you. And did there come a point where you requested an arrest warrant for Jamie Cobey?
Yes, ma'am. Based on all of the evidence I collected, I requested a warrant and arrested Jamie Cobey on June 3rd.
Thank you, Your Honor. No further questions.
All right, thank you, counsel. Cross-examination?
Yes, Your Honor. As the police department's deputy sheriff, you've responded to several altercations between Mr. Smith and Ms. Cody.
Yes, I have.
When you were searching Miss Cobey's residence, you found a jar of rattlesnake rattles.
Yes, I found a small tub on the shelf which appeared to have 5 rattlesnake rattles.
And while you were investigating the crime scene, you found Jamie's fingerprints on Mr. Smith's mailbox. Is this correct?
Yes, I did. I lifted the latent fingerprints I picked off the mailbox were Jamie Cobey's.
And eventually, the fingerprints found on the mailbox were part of the reason that you decided to arrest Miss Cobey.
Yes and no. The fingerprints were a small part which led me to arresting me.
But they still were part of the reason you arrested her?
Yes, ma'am, they were.
But you cannot determine when the fingerprints were made. Is this correct?
No, ma'am, I cannot.
Did you find Miss Cobey's rent check for the previous month on the scene?
No, I did not. She told me that she did drop off rent money. However, I did not find it on the scene or in the deceased's house.
So you didn't see it?
No, I did not.
But you described, and you were the main officer who was conducting the search around the mailbox?
Yes, I was the main officer conducting the search.
Yet you described your search around the mailbox as cursory. Is this correct?
Yes, ma'am, I did.
And you found the mailbox open and empty on the scene when you arrived?
Yes, the mailbox was open and empty when I arrived.
One last question, Deputy. You never heard, during your investigation, you never heard any testimony of anyone who saw Miss Cobey with a rattlesnake. Is this correct?
No, ma'am, I did not.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
No, Your Honor. May my witness be excused?
She may indeed. Thank you, deputy. You may step down. Next witness for the prosecution.
Yes, Your Honor. The people call Terry Edwards to the stand.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform with the facts and rules of the trial composition? Yes. You may be seated.
Again, for scoring purposes, my name is Maggie Templeton.
And for scoring purposes, my name is Bella Taylor.
Thank you.
Good evening, Miss Edwards.
Good evening.
Would you please state your name and occupation for the court?
My name is Terry Edwards, and I'm a retired lawyer.
Where do you live?
I live in Burnsley. After deciding to retire, I moved there to get as far away from offices and paperwork as possible. If I never see another deposition again, it'll be too soon.
Understandable. Do you know the defendant?
Yes, I was there when Jamie and their mother first moved to Burnsley.
Have you personally interacted with the defendant?
Yes, I've had multiple interactions with Jamie throughout the years.
Have you observed the defendant's behavior in any business dealings?
Other than Jamie's breach of contract with me, I know she wasn't a model tenant to Eric Smith, to put it mildly.
How so?
I personally witnessed Jamie throw things in Eric's yard, block Eric's driveway, and make tire tracks in Eric's yard. As my torts professor used to say, Jamie was a private nuisance publicly.
You mentioned the victim in this case, Eric Smith. Did you know Mr. Smith?
Yes, I've lived down the road from Eric for 10 years. I'd say we were friends. We both seemed to have a similar dislike for when people didn't live up to their responsibilities.
I'd like to move now to the funeral held for the defendant's mother on April 28th. Were you aware a funeral was being held?
I was.
Did you attend Mrs. Cobey's funeral?
I did.
At this event, did you witness anything unusual take place?
I heard Jamie saying this was it, and she was finally going to do it. She appeared angry at the time.
Did anything else stand out to you at this time?
Yes, towards the end of the reception, I heard a disturbance outside, so I went to see what was going on.
What did you see?
I saw Jamie and Eric arguing. Eric asked Jamie when she was going to move out, and Jamie seemed to get really upset at this. Jamie then started accusing Eric of killing her mom.
Did Eric respond?
Yes, Eric said, "Me? It's your fault your mom died. You should have been more responsible in taking care of her." I was anxious this would get violent, but so I separated them, and they both left at about that time.
Did you see the defendant again that day?
Yes, a couple of hours after the funeral, around dusk, I decided to check up on Jamie at their residence. For all of her faults, it was a very emotional funeral, and I was concerned about her.
What did you find when you arrived at the defendant's residence?
I saw Jamie in front of her house in her garden. I rolled down my window hoping to talk to her, and that's when I heard Jamie scream.
What did the defendant scream?
Jamie screamed, "I am going to kill him."
Thank you, Ms. Edwards.
cross-examination.
Yes, Your Honor. And for scoring purposes, my name is Carrie Stevick. Ms. Edwards, you described Mr. Smith as your friend. Is this correct?
Yes, I've known Eric for 10 years.
Well, on the other hand, you viewed Miss Cobey as a real pain.
Miss Cobey could do some things that were not okay.
And you attended the funeral on April?
Yes, I did. I wanted to pay my respects.
And you noticed that Miss Cobey was distraught.
Yes, she seemed very upset throughout the entire funeral.
And the last time you had seen Miss Cobey, she was in a heated shouting match with Mr. Smith.
Yes, the last time at the funeral, I saw her arguing with Eric.
And this was a few hours before you drove to her home.
Yes, it was.
Miss Edwards, you're sure your recollection of what you believe you heard Miss Cobey scream that night was entirely accurate?
Yes, I am.
And when you drove to Miss Cobey's home, you mentioned in your statement rolling down the window to talk to Miss Cobey.
Yes, I did.
You rolled down your window and suddenly she screamed. Is this right?
Yes, that is what happened.
But in your statement, you never mentioned getting out of the car.
No, I stayed inside of my car.
You never even mentioned turning off your engine.
No, I didn't turn off my engine.
As far as you're aware, Miss Edwards, there was no one else around other than you and Miss Cobey that could have heard her say this?
Yes, it was only me and Miss Cobey.
And is it possible that with all the added noise from your car...
Objection, Your Honor. Unfair extrapolation.
Could you repeat the question before you respond?
Is it possible that with the additional noise of your car that she didn't hear you correctly?
Would it be helpful for me to elaborate on my objection?
Sure, you elaborate and then you'll respond.
Well, though Ms. Stevick's previous questions, if she ever mentioned turning off the car, turning off the air conditioner, turning off the radio, they were merely asking about the statement. This question specifically refers to all the outside noise, all the other noise, which is never mentioned in the case packet.
Okay, respond.
I didn't say all the other noise. I said the noise from your car, which is fair extrapolation. Hearing that she said herself that she never turned the car off, so it would be fair to say that there is noise coming from her car.
I have no other comment to make than what I have previously said. This other noise has not been mentioned in the case packet and is material, as Ms. Stevick is referring to it, saying it would obscure Miss Edwards' ability to hear Miss Cobey's.
Sure.
I didn't say, again, I only said car noise. I didn't say other noise, so I'm only referring to one thing, which is fair extrapolation, saying a car makes noise, and if she never turned off her car, it's fair to say that there would have been noise from her car, Your Honor.
Though, with the last questions as context, it is clearly referring to the other questions Ms. Stevick has mentioned of other car noise. Anywhere in your statement have you mentioned, I believe it was turning off the air conditioner, turning off the radio?
I actually only said engine.
Okay, talk to me. Don't talk to each other. That's how it works in real court. Unfair extrapolation is such a weird objection because it's basically, is it in the casebook? Can we use it? I think her question was narrow enough. I'm going to overrule the objection, but it's a fine line. So stay on this side of it, counsel.
Would you like me to restate my question?
I don't know, ask the witness.
Would you like me to restate?
Yes, please.
Is it possible that you misheard Miss Cobey in the garden that evening?
Anything is technically possible.
But it is possible.
Technically, yes.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
No redirect, Your Honor. May my witness please be excused?
She may. You may step down, Miss Edwards. Any other witnesses?
Yes, Your Honor. The people call Angel Russell to the stand.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully perform the facts and rules of mock trial competition?
I do.
You may now be seated.
Before the people proceed with direct examination, we respectfully request a time check.
Yeah, you have 3 minutes.
Thank you. Again, for scoring purposes, my name is Maggie Templeton.
And for scoring purposes, my name is Sophia Rask.
Good evening, Ms. Russell.
Good evening.
Would you please state your name and occupation for the court?
My name is Angel Russell, and I'm a line worker for Burnsley County Water and Electric.
How long have you been a line worker in Burnsley County?
I celebrated 15 years just a couple months ago.
Did you know the victim in this case,
I
Eric
knew
Smith?
Smith by sight, if nothing else.
When was the last time you saw Mr. Smith?
When I found his body on April 30th.
I'm sorry, Miss Russell? I know this isn't easy. Let's talk about the day before, April 29th. Where were you that morning?
I was working on one of the poles on Raptor Road. It was about 100 feet down from the nearby houses, 46601 and 46603.
Did anything strike you as unusual as you were working?
Yeah, at about 8:30, someone came out of 46603 and walked towards the mailboxes.
Why did you find this specific person on this day unusual?
Well, all the stuff they were holding, this bulky gardening type bag and a pretty sizable wire cage they kept looking down at.
Is the person you saw that morning present in the courtroom at the moment?
Yes.
Would you please identify them by their location in the room and a description of their clothing?
Sitting at the head of the table wearing the navy blue blazer.
Your Honor, would you let the record show that Angel Russell has accurately identified Miss Cobey as the woman she saw by Mr. Smith's mailbox on the morning of April 29th?
The record shall so reflect, yes.
What did the defendant do next?
Well, I started inspecting the grounding wire. When I looked up, the defendant was standing in front of the mailbox at 46601. I didn't think anything of it and I went back to work, but when I looked again, they were gone.
Did you find anything else significant about this day?
Yeah, at about 12 p.m. I was replacing an insulator cap when I saw Eric Smith walk out of 46601.
Why did it strike you as unusual?
Well, it didn't at first, but then I watched him reach into his mailbox and he reached his hand out and yelled a loud shrieking scream.
What happened next?
When Smith yanked his hand out of the mailbox, envelopes went flying all over the place, and I saw him trying to shake what looked like a snake off of his wrist or hand.
How did you react?
Well, as fast as I could, I climbed down the pole. I screamed for help, but no one came. So I got a breaker bar from my truck, hit the snake off, and kicked it into the bushes.
Did Mr. Smith say anything during this time?
Yeah, when I finally got to him, he shouted, "Jamie."
Objection, Your Honor. This witness's statement contains hearsay.
Your Honor, may I respond?
You may.
Your Honor, anything that Eric Smith said during this time falls under the hearsay exception, excited utterance, as it occurred immediately after an extremely excited event that would later end his life.
May I respond, Your Honor?
You may.
In the witness's own witness statement, they state that after Mr. Smith was bit, Angel Russell climbed down from the pole, ran 100 feet rather, to get to their truck, which had a breaker bar, and then ran 100 feet back to get back to Mr. Smith. There's simply too great of a length of time to conclude that it could have been excited utterance, because there's too much time between when the event happened, the bite from the snake, and from when Mr. Smith yelled.
Your Honor, may I respond?
You may.
The exciting event is not just Mr. Smith reaching his hand into the mailbox and the snake coming out and biting him on the wrist. The exciting event is Angel Russell running down, beating the snake, killing the snake, and kicking it into the bushes. All extremely exciting incidences.
May I respond?
Sure, go ahead.
My final remark is that there clearly would have been enough time for Mr. Smith to think intentionally about whatever he was going to say because of that great length of time. I don't think it's reasonable to assume that he was still under the stress of the event, as I previously stated.
Your Honor, may I respond?
Yeah, sure, why not?
My question is, did Mr. Smith say anything during this time? Mr. Smith clearly said this immediately after or during Miss Russell kicking the snake, beating the snake, all of these events, which are exciting.
It's a close one. I think because hearsay is stating something to prove the truth of the matter asserted, and I don't know what truth you can prove just by saying Jamie, I'm going to overrule the objection, but if you want to follow up on cross-examination to ask, like, do we even know what Jamie she's referring to, you're welcome to do that, counsel. So we're going to overrule the objection for the moment.
And Miss Russell, did you get the time to finish your response?
Yes, I did.
Now, did you see Mr. Smith again?
Yes. He was face down in the dirt in his own front yard. I called 911. I checked for a pulse. It was so terrible. I mean, he was still in his pajamas.
And just for clarification, when was this?
The morning of April 30th.
Thank you, Ms. Russell. No further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor. For scoring purposes, my name is Amanda Town. Permission to proceed?
You may.
You believe that the pole that you were working on the morning of April 29, 2021, was about 100 feet away from Mr. Smith's residence, correct?
Yes, it was 100 feet away from the nearby houses 46601 and 46603.
And that's when you saw Jamie walking out with a metal cage, correct?
Yes.
But you can't confirm that there was anything in the cage itself, can you?
No, I couldn't really see. All I could really see is that there was a cage itself.
And for that matter, you didn't even see Jamie open the mailbox at any time, correct?
No, when I saw Jamie, I didn't think anything of it and I went back to work. When I looked up again, she was gone.
Now, Jamie wasn't wearing snake-proof boots from what you could tell, was she?
No, I was pretty drawn to the cage itself, so I didn't really get a look at her shoes.
And to your knowledge, she wasn't wearing snake-proof gloves either, was she?
Again, drawn to the cage itself, didn't really tell if there was gloves or not, no.
Thank you, Miss Russell. When you saw Mr. Smith fall to the ground, you also saw some envelopes fall to the ground with him. Is that true?
Yes, when he pulled his hand out of the mailbox, envelopes went flying all over the place.
And right after that, right after he got bit, that's when he shouted Jamie. That is right?
Yes.
But he never explained to you what he meant when he shouted Jamie, did he?
Well, given the situation that he had just been bit by a snake, I don't think that would have been appropriate, so no.
So he didn't?
No.
And for that matter, because he never explained to you what he meant, and because that statement is so vague, you don't know which one of the millions of Jamies in the world he could have been referring to at that moment. Isn't that true?
Again, given the circumstance, I don't think it would have been appropriate to further discuss the Jamie, so no, I do not know.
Thank you. Your Honor, no further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor.
You may proceed.
When you saw Jamie Cobey on April 29th, what were you focused on?
The cage that she was holding.
Could you have overlooked any other details about the scene because you were focused on this particular part of their appearance?
Yes, I was only really looking at the cage and didn't think anything of it, so I quickly went back to work, so I didn't really get a look at anything else.
Thank you, Ms. Russell. No further questions. May this witness please be excused?
They may. You may step down, Miss Russell. Thank you. Does the prosecution have any further witnesses to call?
No, Your Honor. The people rest their case.
All right, the people having rested, does the defense have any witnesses to call?
Yes, Your Honor. The defense would like to call Dr. Tyler Clay.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform with the facts and rules of mock trial composition?
I do.
You may be seated.
You may proceed when ready, counsel.
Once again, my name is Valerie Moore.
And once again, my name is Genevieve Land.
Please state your name and occupation for the court.
My name is Dr. Tyler Clay, and I'm the director of the Southland Zoological Museum.
What qualifies you to be working on this case?
I got a Bachelor of Science degree in biology at Central State University in Cali back in 2000. Then I got my master's and doctor's at the University of Central California in biology, specializing in herpetology, which is the fancy way of saying I love snakes.
How are you involved in this case?
I've gone over the medical examiner's reports of Mr. Smith a few times and was able to see the old girl that bit him.
Do you have any personal experience with the Mojave rattlesnake in the desert environment?
Yes, Cortalis scutellatus, which is the fancy term for the rattler, are absolutely beautiful creatures. Being from the desert myself, I've actually caught a few and studied them firsthand.
That's really interesting. Can you tell us a bit about the risks that people face from this type of snake?
Listen, she is not a snake to mess with. Mojave rattlesnake bites can be extremely dangerous without proper treatment and antivenom. Because people, like Mr. Smith, may underestimate how dangerous her bite is, they may skip the antivenom, leading to their death.
You mentioned earlier you examined the snake in this case. Did the snake you examined have a rattle?
No, the poor girl did not have her rattle.
How likely is it for the rattle to come off naturally?
It is actually more common than you might think, and entirely consistent with how all rattlesnakes shed their skin. In an effort to remove dead skin, they can inadvertently pull off the rattle, like if they get stuck in between two rocks.
Speaking on the behavior of rattlesnakes, could you tell us a bit about the habits of this type of snake pertaining to their sheltering preferences?
It is common for snakes to hide out in dark places during the day to shelter themselves from the sun. They are experts at finding and squeezing into tight hiding places.
What is the likelihood a snake would go into a mailbox on its own?
A snake is willing to hide in many places to get out of the sun, and to a snake, a mailbox is the perfect place to hide out. So it would be very likely that a snake would go into a mailbox either through a front mailbox door or a top slit if the mailbox had one.
How dangerous would it be for someone without professional knowledge to attempt to handle a Mojave rattlesnake by placing it into a mailbox?
Dumping a rattler into an open mailbox door, even with gloves, as Dr. Dunn has suggested, would be an extremely risky action for someone holding the trap, especially if they did not have any professional knowledge.
In your professional opinion, what do you think the likelihood of Eric Smith's death would have been if he had gotten the proper treatment?
If Mr. Smith had gotten proper medical attention, I think that it would be extremely unlikely that her bite would have killed him. Death from Mojave rattlesnake bites is extremely rare, especially in desert communities, because bite victims generally seek out antivenom as soon as possible.
No further questions at this time.
Thank you, counsel. Any cross-examination?
Yes, Your Honor. And for scoring purposes again, my name is Claire McCoy.
Thank you.
Dr. Clay, in order to ensure the best handling of a rattlesnake possible, wouldn't one elect to use snake tongs, gloves, snake-proof boots, and a humane animal trap?
Yes, that is the best way.
And isn't it true that a Mojave rattlesnake's venom does not cause serious symptoms until hours after the bite takes place?
Yes.
And it's common for victims to be lulled into a false sense of security because of the delay in symptoms, correct?
Yes, they get lulled into a false sense of reality, and that's usually what causes the death.
So considering that, it's plausible that Eric Smith wouldn't have known to seek medical help until it was too late.
No, usually people from the desert tend to seek out antivenom as soon as possible. It's common knowledge around here.
But because of the delay in symptoms, you just said that it is plausible that he could, because of the delay in symptoms, it is possible, correct?
It is possible, but generally people around here seek out antivenom as soon as possible.
Doctor?
Yes.
Rattlesnakes alert a person with a rattle auditorily, correct?
Yes, they shake whenever they are threatened.
So if someone wanted a rattlesnake in a mailbox to go unnoticed auditorily, they would need to cut off the snake's rattle, correct?
That would be the best way, but it's very inhumane to the snake.
You are familiar with Dr. Dunn's testimony, yes?
I've heard it, yeah.
And you are aware of Mr. Smith's pre-existing medical conditions?
Yes, his heart disease and kidney problems.
And you previously stated that these medical conditions are likely what killed Smith, correct?
Correct, this is most likely.
You do realize that Dr. Dunn, the medical examiner who performed the autopsy on the victim, disagrees with that, even with his conditions, correct?
Yes, Dr. Dunn and I disagree on this matter.
And that, you know that determining cause of death as a herpetologist is out of your expertise.
Yes, but I have learned a fair amount about this snake in this case, and without proper antivenom, his death was most likely.
You did not go to medical school, correct?
No.
And it is not, and as a herpetologist, you are not able to determine the cause of death, correct?
No, but I have gone over this case in extreme detail, and this is what I believe.
Yes, doctor?
Yes.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
No, Your Honor.
You may step down, Dr. Clay. Thank you very much. Watch your step. Other witnesses for the defense?
We should just have this with even the expert witnesses on the defense.
No rush. Don't worry.
Yes, Your Honor. The defense calls Francis Yazzie to the stand.
All right.
Do I stay here for cross?
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform with the facts and rules of mock trial competition?
I do.
You may be seated.
For scoring purposes, my name is Sienna Keebler.
And for scoring purposes, my name is Amanda Tao. Permission to proceed?
You may proceed.
Good evening, Ms. Yazzie. Please state your name and occupation for the court.
My name is Frances Yazzie. I used to own a restaurant called the Blue Agave until it was shut down due to COVID-19. My true passion is art, and so now I create watercolor paintings and jewelry. to earn some income.
Do you happen to know the defendant in this case, Jamie Cobey?
Yes, Jamie has been an amazing friend and a kind neighbor for the past 10 years now. Jamie used to also work for me in my restaurant.
When you learned that Jamie Cobey was being charged for the death of Eric Smith, what was your immediate reaction?
I was shocked. The Jamie I know is so patient and compassionate. I could never imagine her hurting somebody, let alone killing somebody at an animal's expense. I cannot wrap my head around that.
Now, I want to talk about Cobey's late mother. Are you aware that Jamie held a funeral for her mother?
Of course, she was a kind woman, but Jamie did come to my home after the funeral around 4 p.m., just as she always does.
And did you happen to hear about what happened at the funeral?
I heard that Jamie and Eric got in a heated verbal argument. Jamie did seem upset when she came to my home.
What did the two of you talk about in particular after the funeral?
Honestly, Jamie was mostly quiet. She would mention every now and then how hurt she felt or how much she missed her mom. She looked so sad. I did my best to lighten the mood as much as I could.
From what you could see during your time together, did you notice Miss Cody's mood seem to change at all?
Oh, absolutely. About an hour after she came to my house, Jamie looked completely normal again. I mean, she was laughing off the argument, saying Eric is just being Eric. She then said how exhausted she was and that she just wanted to go home and relax and garden.
So, just to be clear, Miss Yazzie, by the time that Jamie left your residence, she didn't seem angry at all, did she?
No, ma'am, she did not.
Thank you. No further questions at this time.
Thank you, counsel. Cross-examination.
Again, for scoring purposes, my name is Bella Svanberg. And for the court's convenience, this witness's testimony can be found on page 47 of the case packet.
Thank you.
Good evening.
Good evening.
So after the pandemic started, Jamie would often come to your home in the evenings to talk and hang out, is that right?
Yes, ma'am, that's correct.
And do you ever mention having any of your other friends come over in the evenings to talk and hang out?
From the Blue Agave, no.
Moving on to April 28th, Jamie visited you that evening, right?
After the funeral, yes, she did.
And according to your statement, you observed that she seemed to be in a pretty agitated state. Is that right?
Well, coming from her mother's funeral, I assume she would.
For the next hour, you mentioned how Jamie appeared to be more calm. Is that right?
Yes, that is correct.
And so within that hour, Jamie had the time to think and reflect on what happened previously at the funeral, correct?
Objection, Your Honor. This question calls for speculation.
Your Honor, may I respond?
You may.
I'm asking if the witness noticed that Jamie had the time to think and reflect on the situation. It is there to prove subsequent action and not for the truth of the matter.
May I respond, Your Honor?
You may.
I don't see how Miss Yazzie could be in the mind of Miss Cody or know what Jamie was thinking about and whether Jamie would have had the time at any part of the day, since she was so busy, to consider what the prosecution is saying, consider what Mr. Smith had done.
Your Honor, may I respond?
Yes.
Well, considering the previous question where I asked that Jamie had an hour, after an hour she appeared more calm, it is fair to assume that she had time to think and reflect on what had happened.
All right. To quote Futurama, you are technically correct, the best kind of correct, because you're asking specifically about whether there was time and not whether she actually did reflect. On that technicality, I'm going to overrule the objection. But again, feel free to make it a point on cross. You may proceed, counsel.
Moving on, so you had absolutely no contact with Ms. Cobey throughout the next couple of days, is that right?
After the funeral, no. I assumed Jamie was taking care of her mother's death.
And that no contact includes April 29th?
Yes, ma'am, that's correct.
Thank you for explaining. Moving on, you spoke to Eric Smith on a few occasions asking that he leave the Cobeys power on, is that right?
Well, I tried. I can't say it was effective.
And those were the only occasions you ever spoke with Mr. Smith?
That's correct.
And just after those few occasions, you mentioned that you wouldn't be surprised to learn that someone had killed Mr. Smith.
Yes, I did mention that.
And Eric Smith wasn't your landlord, right?
No, he was Jamie's.
And you did not have to live next to Eric Smith?
No, ma'am, I did not.
And your power was never shut off by Eric Smith, is that right?
Well, he wasn't my landlord, so he didn't have the power to.
Thank you, Your Honor. No further questions.
Thank you, counsel. Redirect.
May I ask for a time check first on behalf of the defense and the prosecution?
You have 6 minutes and you have 852 seconds.
8:52, you said? Thank you.
No redirection, Your Honor. May I witness the witnesses?
Yes, you may step down, Ms. Yazzie. Did I say make it a point on cross a minute ago? It's your witness. I meant redirect. Sorry. Okay. Anyway, I assume the defense has further witnesses to call?
Yes, Your Honor. The defense would like to call to the stand Danny Emily.
All right.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform to the facts and rules of mock trial composition? I do. You may now be seated.
And for scoring purposes, my name is Carrie Stevick.
You may begin, counsel.
Please state your name for the court.
My name is Danny Emling.
What do you do for a living, Miss Emily?
I own a little convenience store in Burnsley, Emling's Things.
Do you know Jamie Cobey?
Of course. We're good friends and neighbors.
So how would you describe your interactions with Miss Cobey?
Well, Cody did some beautiful yard work for me a while back, and we do the usually neighborly chit-chat.
Did you know Eric Smith?
Yes, he was my landlord and neighbor.
How would you describe your interactions with Mr. Smith?
Honestly, not the greatest. He was rather rude and critical even when I didn't ask for his opinion.
And to your knowledge, Miss Emily, was Mr. Smith rude or argumentative with his other tenants?
I have seen him argue with another tenant, but that's the effect Eric just seemed to have.
Thank you, Miss Emily. Going back to Miss Cody, would you please describe for the court Miss Cody's general demeanor?
Jamie is just so full of love for her mom, for animals, and for gardening. She's the sweetest pie. Apple pie, none of that sour rhubarb stuff.
Thank you. Miss Emily, have you ever seen Miss Cody angry or upset?
Of course, we all get upset now and again, but Jamie usually cooled off pretty quickly, and Jamie isn't really the type to hold a grudge.
Have you ever seen Miss Cody and Mr. Smith together?
It could be quite hard to miss them. They're usually bickering about something. I actually did see them argue back in Jamie's mom's funeral.
Can you briefly describe for the court what you witnessed between the two of them at the funeral?
Of course. I didn't catch all of it, but I did hear Jamie yell at Eric to leave since he had not been invited to the funeral.
And Miss Emily, where were you at the time of Mr. Smith's death?
I was outside of the county visiting some family, and I didn't actually hear about Eric's death until I received a phone call about a month later from Deputy Sheriff Garrett.
So Miss Cody, Miss Emily, why are you testifying on behalf of Miss Cody here today?
Well, seeing as we were both tenants of Eric, we've had similar experiences, and the Jamie I know is just so kind and friendly. The Jamie I know would never hurt anyone or anything.
Thank you. Finally, Miss Emily, your fingerprints were found on Mr. Smith's mailbox along with Miss Cobey's. Can you briefly describe what they were doing there?
Of course. I pay my rent by putting it in Eric's mailbox. I don't recall touching the mailbox the last time I did, but I could have at any time. I just don't really know when.
Thank you, Your Honor. No further questions.
Thank you, counsel. Cross-examination, anyone?
Yes, Your Honor. Once more, my name is Claire McCoy. Miss Emling, you believe Eric Smith to be a terrible person, correct?
Well, as I stated previously, my experiences with him weren't exactly the greatest, so I would have to say yes.
You also believe Jamie Cobey to be a great person.
Once again, as I stated, Jamie and I were rather close friends and we would talk often, so yes.
Considering your history with Smith, it's fair to say that you would testify in favor of Cobey. Is that correct?
Once again, my experiences with Cobey and our relationship is much closer than I've had with Eric, so I would have to agree.
Thank you, Miss Emling. Next,
I'd like to turn your attention back to your comments on Mr. Smith's behavior. Mr. Smith never blamed you for the death of a close family member, right?
I have never had an interaction with him such as that, no.
And he never placed a camera in your backyard?
Objection, Your Honor. Relevance. This poses no relevance. The witness has clearly stated that she shared similar experiences, but she never specifically said that there was a camera pointed in her backyard. And for further, there's no relevance to this. What are you trying to prove by saying this, other than Ms. Emling's experiences were slightly different?
Well, I don't know. Let's ask her.
Your Honor, may I respond?
You may.
I'm trying to prove foundation for later questions, and I'm trying to prove that that Miss Emling has not had the same experience as Cobey, and she will therefore not be able to testify to what Cobey would or would not do in the same situation that she was in.
You brought up the similar experience thing on direct. I think it's fair game for cross-examination. I'm going to overrule the objection for the moment.
Thank you,
Please
Your
proceed.
Honor. Would you like me to repeat the question?
Yes, please.
And Smith never placed a camera in your backyard, correct?
He has never placed a camera in my backyard, no.
So considering this, it's fair to because you haven't had the same experiences as Miss Cobey, you cannot testify to what Cobey would or would not do to Smith, correct?
As I stated previously, I have had similar experiences, just not the exact same.
So because of that, you are not able to testify to what Cobey's actions would or not be towards Smith, correct?
Not exactly, no.
Were you in the county at the time of Mr. Smith's murder?
No, I was outside the county visiting some family.
And therefore, you have no first-hand experience of Miss Cobey's behavior from after the funeral to before Mr. Smith's death. Is that correct?
No, I was outside of the county visiting family.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
No, thank you. May I please be excused for the stand?
Yes, Ms. Emily, you may step down. Thank you.
The defense calls Jamie Cobey to the stand.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform with the facts and rules of law and trial competition?
Yes.
You may be seated.
For scoring purposes, my name is Caitlin Reynolds.
And for scoring purposes, my name is Amanda Camp. Permission to proceed?
Proceed.
Good evening.
Good evening.
Please state your name and occupation for the court.
My name is Jamie Cobey. I previously worked at the Blue Agave restaurant before COVID, but now I work in xeriscaping, which is basically desert landscaping.
As a xeriscaper, what kind of work do you do?
Well, I mean, working outside in the desert all day, I have to take extra precautions with animals around me. By doing this, I make sure to take part in my research, local animal rights organizations, and buy the proper animal-proof equipment, such as snake-proof gloves.
Where is your current residence?
I've lived at 46603 Raptor Road in Burnsley, California for about the past 10 or so years.
And do you live with anybody currently?
No, I don't anymore, as sadly my mother passed away a few months ago.
I'm very sorry to hear that, Ms. Cobey, and it is a topic that I do need to come back to at a later time, but first I wanted to ask you, do you own the home that you live in?
No, I rented it from Eric Smith, I guess.
And how would you describe your relationship with Mr. Eric Smith?
Not great, to be honest. He would blast music really loudly at night, and he would rarely fix anything when I asked him to. The worst thing he did was, when I didn't turn in my rent when it was due on in time, he would turn off my power and water. That upset me the most.
Why did turning off the utilities upset you the most?
My mom, you see, she relied on a respiratory device to breathe. We even called it the breath of life. Well, anyways, even though I was short on money, I was always trying to turn in my rent when it was due on in time. I needed Mr. Smith to know we had to live there.
Did you ever try to do anything to get back at Mr. Smith?
Once I was frustrated, so I left dried coyote scout on his front porch. It was stupid and a silly joke, and I shouldn't have ever done it, but I promise that's the only thing I ever did.
Now, I want to return back to the subject of your mother. Can you please just briefly describe the events that led up to her passing?
I was gardening. Mr. Smith turned off our power and water once again. Therefore, my mother's oxygen machine tank shut off. I found my mother struggling to breathe, so I drove her the 45 minutes to the nearest hospital, but it was too late.
Do you blame Mr. Smith at all for your mother's death?
I don't blame Eric entirely for my mother's death, as I do believe with her illness, it was only a matter of time before she passed. I guess I just didn't think it would be so soon.
Did you end up holding a funeral for your mother?
Yeah, I held a funeral about a week after her death.
How were you able to pay for this funeral?
Well, like I said, I barely had any money to spare, so I did everything I could. I sold most of my gardening tools, like my animal humane trap, snake tongs, and animal-proof gloves and boots.
And did you invite Mr. Smith to this funeral?
No, I didn't invite Eric, nor did I want him there, but he showed up anyways.
Did you happen to interact with Mr. Smith at the funeral?
Well, if I'm being honest, we did get into a very heated argument. Eric asked me when I'm moving out, and the rest, it was all kind of a blur. I don't really remember. Although, I do remember blaming Eric for my mother's death. I regret saying that.
What happened next?
After that, I went to Yaz's place to cool and calm down and talk through things, and I left her house early, and I went back to garden to kind of recollect my thoughts.
Now, one of the biggest claims in this case is that you were heard shouting, "I'm going to kill him," while gardening. Are you able to clear up this misconception at all?
Of course. Well, as I was gardening back at home, I saw that some snails and some rabbits had eaten away at my succulents. I was so mad that I yelled, "I'm gonna kill him!" But I promise I would never intend to harm an animal. It was all of the heat of the moment thing. Succulents are just my prized possessions.
Can you please say the phrase, "I'm going to kill him," like you normally would?
I'm gonna kill him.
And can you please say the phrase, "I'm going to kill them," like you normally would?
I'm gonna kill him.
Objection, Your Honor. Unfair extrapolation. Would you like me to elaborate on my objection?
Sure, yeah, somebody say something. Go ahead.
Well, the creation of a material fact is unfair extrapolation. The material fact being created here is the specific pronunciation of "I'm going to kill him" and "I'm going to kill him." Miss Tam here is clearly making the point that these two phrases coming from the mouth of Jamie Cobey are interchangeable, when in fact that is never said in the case packet and never stated phonetically how she would say these two phrases.
May I respond, Your Honor?
You may.
I don't believe I'm creating a material fact here. She's simply repeating what has been said in the case packet, that two different things were heard, and that she believed that she said, "I'm going to kill him." The fact that there was ambiguity, the fact that nobody's quite sure what she said, falls in line with the fact that she said something that could have been heard in two different ways.
Mr. Tomczak, may I respond? Your Honor, may I respond?
Yeah.
The point that the two phrases were interchangeable was made previously with Miss Tam's previous.
Okay, something's on the PA system for those at home. Okay, we're good. So yeah, if we could shut both those doors just to prevent the vacuum. Continue, Ms. Templeton.
The point that Ms. Cobey was misheard, that she said, "I'm going to kill them," instead of "I'm going to kill him," as she has claimed, was already made in Ms. Tam's previous question, which was, "Can you clear up this misconception?" Therefore, to make this point, she does not need these new two questions that are creating the material fact of the pronunciation of "I'm going to kill M."
May I respond, Your Honor?
Sure.
I believe that sounds a bit more like a relevance objection, to which I would say that the relevance of this is showing the court how this could have been misheard. Because it could be difficult to imagine how him and them could be misheard, but when you put it together as you can see how it sounds similar. I believe it provides a very effective example.
Your Honor, may I respond?
Yeah, sure, why not? Go ahead, respond.
It is still creating this pronunciation. This pronunciation was not said in the case packet. That there was ambiguity has already been said, has already been stated. These questions are not necessary, and these questions are creating the material fact of this pronunciation. "I'm going to kill M."
Okay. Yeah, this, again, unfair extrapolation, weird objection. I think, counsel, you've already established that your claim is that she said, I'm going to kill them. Prosecution claiming said, I'm going to kill him. It's an issue of fact for the trier of fact, which I guess is me, to decide if those things actually sound similar. So in terms of the pronunciation questions, we're going to sustain the objection on those. I think you made your point without them.
Motion to strike.
Those questions and the answers will be stricken from the record. Thank you, counsel. Yeah, before you proceed, counsel, can we try changing out your lav for the one on the table? Just to see if that helps with some of the auditory stuff. Because that's our good lav, so it's either that or it's the transmitter. And I'm really hoping it's not the transmitter.
Permission to proceed, Your Honor?
Proceed, yeah.
Thank you, Ms. Cody. Now, my final point is I just want to talk about the morning of April 29th, 2021. What were you doing that morning?
Well, I went to Mr. Eric Smith's mailbox to drop off $48 of my rent.
Did you happen to be holding anything else at the time?
Yeah, I was holding my humane animal trap. Like I said earlier, I carry it around sometimes to catch or release animals safely in the wild.
Finally, Ms. Cody, did you kill Eric Smith?
No, I did not kill Eric Smith, nor did I want him dead. I mean, I didn't like him, but I would have never wished to see him die.
Thank you. No further questions, Your Honor.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Before the people proceed, we request for a time check.
Yes, you have 4 minutes and 23 seconds.
4:23. Thank you.
And you have 1 minute and 8.
Thank you.
Again, for scoring purposes, my name is Maggie Templeton. Ms. Cobey, let's be clear. You were at Mr. Smith's mailbox on the morning of April 29th, yes?
Yeah, I was dropping off $48 of my rent.
And on this morning, you carried with you a wire animal trap, yes?
Yes, that's correct.
And in addition to this trap, you have many other tools necessary to handle venomous snakes, yes?
Yeah, my snake tongs, animal-proof boots.
This is not necessary, just the yes or no, please?
Yes.
Thank you. And you also have the knowledge to handle venomous snakes as a desert resident and active gardener, yes?
That's correct. I work with them a lot, actually.
You've even researched the Mojave rattlesnake specifically?
Correct. They're actually 16 times more venomous than most of the snakes in the desert.
Thank you, Ms. Cobey. I'd like to now move to your life preceding Mr. Smith's death. You and Mr. Smith have had issues for years now, haven't you?
Yeah, a lot of issues.
You would blast music early in the morning?
And at night, too. Yes.
He placed a camera peering into your backyard, is that right?
Yeah, he did.
And you describe this as creepy and weird?
I mean, why wouldn't it be creepy or weird?
And you've called the sheriff about Mr. Smith several times, haven't you?
Yeah, I have.
But nothing changed, did it?
No, it didn't.
And Mr. Smith would shut off your power and electricity?
Yes, he would.
He did this on April 22nd, yes?
Yes.
The day your mother died?
That's correct.
And then Mr. Smith showed up to your mother's funeral, is that correct?
That's correct. I did not want him there, nor was he invited.
So you and Mr. Smith naturally got into a heated argument?
Yeah.
And this argument got so heated, you can't even remember everything that was said, is that right?
That's true. I mean, I was just grieving over my mother's death. I couldn't think about our conversation, really.
Thank you, Ms. Cobey. No further questions.
Counsel, redirect?
Yes, Your Honor. Just 2 quick questions, Ms. Cody. The loud music that Mr. Smith would blast, did it disturb anyone else in your household as well?
I mean, not exactly. I mean, I was always trying to care for my mother, and she was often tired from all the treatment she was receiving, but I wouldn't necessarily say it really bugged either of us.
Thank you, Ms. Cobey. And just for clarification, again, why do you have these snake handling equipment, tools, such as the snake tongs, the snake boots, etc., all those materials that you previously mentioned?
I mean, more importantly, it's for my own safety. I mean, and others too, of course. But I always try to keep proper handling of these venomous snakes in the wild, and obviously I don't want to hurt my own self when I'm handling something I love.
Thank you. No further questions, Your Honor. May the witness please be excused?
Yes, you may step down, Ms. Cobey. We'll proceed with closing arguments momentarily. For the defense, I think that lav is the winner, so if you could hand the lav and the transmitter to Ms. Stevick so she can do closing when it's her turn, please. All right.
Rest our case?
Oh, yeah, if you want to rest, sorry.
Yes, the defense rests their case.
Sure, rest it. Closing arguments, okay. Does the prosecution want to make any?
Yes, Your Honor.
You may proceed when ready.
Jamie Cobey was brought to the brink and pushed one more time. The final push supplied the motive to plan to kill Eric Smith and follow through with such a plan. Poison Smith and do nothing while he died of a painful envenomation in the desert heat. Your Honor, the people charged Jamie Cobey, the people asked that the court charge Jamie Cobey with first-degree murder or the lesser-related charge of voluntary manslaughter. According to Calcrim 520, the people must prove beyond a reasonable doubt that the defendant killed without lawful justification, that she acted with malice of aforethought, and that they committed the act that ended the victim, Mr. Smith's, life. That the defendant acted with lawful justification or excuse is not a viable argument in this court, as vengeance is never a viable excuse in this court. The defendant clearly acted with express malice towards the victim, as Terry Edwards testified, when she said the most malicious statement of all, "I am going to kill him." Yes, Eric Smith did have underlying health conditions, but they were nothing compared to the venomosity, to the deadliness of the Mojave rattlesnake. As Dr. Charlie Dunn stated, the snake's venom is 16 times more potent than that of other rattlesnakes, 16 times more deadly. Not to mention the delay in symptoms, not to mention the effect of the delay in symptoms had on the victim. And when the distinguishing characteristic of a rattlesnake, its rattle, is gone, it's even harder to identify. Deputy Sheriff Tony Garrett has dealt with the constant animosity between Cobey and Smith for years, 10 to be exact. Smith played obnoxiously loud music, crushed Cobey's prized succulents, and even shut off Cobey's power without warning, leading to the preventable death of her mother. Leading to the preventable death of her mother. I'm sorry.
It's okay.
With that, not only did Cobey lose her mom, who she had cared for the last 10 years, but Cobey also lost her primary source of income, Mrs. Cobey's disability checks. She was unemployed, alone with her grief, and desperate for a way out. These were just some of the actions that brought Jamie Cobey to the brink. She was pushed and pushed and pushed for a decade. And when Smith came to Cobey's mother's funeral, uninvited, and blamed her for the death of her own mother, that was the final offense that pushed Miss Cobey over the edge. As if the last 10 years of hard work and love and care had never happened, were for nothing. That's when Miss Cobey became not just sad, not just distraught, but angry, vengeful, murderous. She thought about it, slept on it, shouted it, and then made a clear, conscious choice. The defendant knew the deadliness of the Mojave rattlesnake's venom. She knew how to get the snake into the mailbox unnoticed. And she knew that Eric Smith would retrieve the rent check in the mail, one Miss Cobey knew she would never have to give. Then she sat in her house, only feet away from her dying neighbor, and did nothing.
The evidence proves more than beyond a reasonable doubt that the defendant acted on a premeditated, murderous intent. Eric Smith was not a good person, but by no means did that warrant his violent murder. For these reasons, the people ask that the court find the defendant guilty on the charge of first-degree murder and the lesser-related charge of voluntary manslaughter. Thank you.
Thank you, counsel. Closing arguments for the defense? All right. Once again, don't forget to project, especially with the mic thing. So.
Throughout the trial of Ms. Cobey, people have attempted to paint a picture of her as this caring, loyal, wonderful daughter, saying that she committed such a heinous act to end the life of another human being. They have not proven beyond reasonable doubt that Ms. Cobey is responsible for the tragic death of Mr. Smith. Access is not the same as use, and grief is not the same as vengeance. And that was all it was. Grief of a lost mother. It is not responsible for the tragic accident that was Eric Smith's death. And that's all it ended up being. A tragic, freak of nature accident. This case ultimately comes down to if there's a reasonable doubt that Jamie Cobey committed the act that ended Smith's life, which would have been catching a rattlesnake, cutting its rattle off, and then placing it in the mailbox of Mr. Smith, hoping that it would eventually bite and kill him. The people's theory, though, fails at several points. As Danny Emlin told us, Miss Cobey was a wonderful, caring daughter who would never hurt any animal, let alone a rattlesnake. And for that matter, there is no evidence that Miss Cobey ever possessed a snake. At most, the collection of rattles that Deputy Garrett mentioned, but Dr. Clay is the only expert present here today that can testify on snake behavior, and she is readily available to testify that snakes come off in the wild, and she's seen it before, and that it is common. The people imply that Jamie Cobey would mutilate multiple snakes and keep the rattles as trophies, in contrast to everything that we have heard about her tonight. No. The fact of the matter is, there is not a single piece of credible evidence that Jamie ever caught or possessed a snake. Yes, she has done her research, and she has the appropriate tools to handle such a snake, as anyone who lives in the desert and has to deal with wild animals every day would do. But the people can put the trap in her hands. They can put the gloves, the boots, and even snake tongs in her hands, but they cannot, and will never be able to put a snake in Miss Cobey's hands. Not to mention that, as Angel Russell stated earlier today in court, that she was so focused on the cage that she never even said she couldn't have definitively say that she saw Miss Cobey open the mailbox on that day. This tragic accident that was Mr. Smith's death occurred because the snake went into his mailbox searching for shelter for what would soon be the hottest part of the day. The people say this unlikely, counting on our disbelief. With all due respect to Dr. Dunn, who I'm sure is a phenomenal medical examiner, again, when it comes to the matters of snake behavior, Dr. Clay is the only person in this room who is qualified to testify on behalf of and testify on snake behavior. And she readily agrees that a snake would seek out this mailbox, and she has seen it before. To those who know snakes, there is no suspicion here, nothing improbable, nothing even reaching beyond a reasonable doubt. Finally, the people have told us tonight relies almost entirely on Jamie's perceived motive for the death of her mother that Eric Smith caused. Yet Jamie has told us herself she didn't entirely blame Mr. Smith for the death of her mother, and in a way she is glad that her mother is no longer suffering. All the people have shown is that an argument took place because Mr. Smith showed up to a funeral that he was not invited to. Your Honor, Jamie left. She didn't retaliate, she didn't escalate, she vacated. We all heard Francis Yazzie. Within a couple hours, she had calmed down, Jamie had cooled down, processed, and moved on. Just Eric being Eric. Now to what Terry Edwards supposedly heard that after the funeral that night. Let's put it in context. Miss Edwards had just pulled up, And the last time Miss Edwards had seen Miss Cobey was in a distressed state after having an argument with Mr. Smith. So it's natural for her to believe that what Miss Cobey would have said is him and not them. About a similar pair of words you can get when said naturally and quickly. But there's no definitive proof of vengeance, not by a mile. Never blame malice for what can be explained by misfortune. To the people, Jamie Cobey is the means to an end. When a tragic accident occurs, people often search for a reasonable explanation and try to make sense out of why this could have happened. And yet, whether discussing means or motive, people have not proven beyond a reasonable doubt that Miss Cobey would have done this. And according to California 520, the defendant committed an act. They have not proven that. There is still plenty of reasonable doubt present in this case. Jamie Cobey did not want Eric Smith dead. Reasonable doubt is more than prevalent. The burden of proof has not been met. And for these reasons, we ask that you find Miss Cobey not guilty on the charges of first-degree murder and voluntary manslaughter. Thank you, Your Honor.
Thank you, counsel. Under mock trial rules, both sides are allowed 1 minute rebuttal after closings. Would the prosecution like to make that rebuttal?
Yes, Your Honor. Throughout this trial, the defense's argument has been completely based off of opinions and personal connections to the witness, whereas the prosecution has been using concrete facts, evidence, and a solid timeline to prove their argument. Jamie Cobey had the motive, the intent, and the capability of causing Eric Smith's death. The defense can try and spin Eric Smith's death as a tragic accident, but there is just too much evidence pointing to Jamie Cobey. Thank you.
Thank you. And rebuttal from the defense.
Yes, Your Honor. As the prosecution stated that we have no solid evidence and we only have people testifying of the character of Miss Cobey. But as we see, we have Dr. Clay present who testified on behalf of Snake Eating here today and told us that these actions that the snake did were not uncommon. And so I believe that we do have plenty of evidence that say that Miss Cobey is not guilty. Thank you, Your Honor.
Thank you. Okay. Well done, both sides. To those at home, my mock trial veterans who are scoring, if you could submit those scoring forms now, please. We're going to take a brief interlude here, about 15 minutes or so that I can compile the scores. Don't get up yet. Hang on. Whoa, slow down, slow down. We all want to get out of here. Can take a brief interlude of about 15 minutes so we can get these scores compiled. We're going to come back. We're going to do, we're going to announce the winners. We're going to announce the verdict. We're going to do all of that. So could we pull up the wellcam and caption 2, please? Because those of you at home, you can go to tinyurl.com/CobeyVerdict and tell us what you think. Was Cobey guilty beyond a reasonable doubt, or should they be acquitted? All right, we'll see you back here in about 15 minutes. All right. Yes, now, bailiff. Thank you, bailiff. That's her favorite part. Welcome back. Court's back in session. Gavel says so. So, before we get into the actual results, I said at the beginning, a lot of people to thank. I'm going to make this as quick as possible. First, I want to just generally thank everybody who stopped in to watch tonight. I purposely didn't tell these guys how many people signed up for this, but just so you guys know, you had an audience of somewhere over 60 people at its peak. So really well done. No, seriously, that was an excellent job. So thank you all for tuning in to this point. A lot of people who made tonight possible. I want to, there's a number of people like Mr. Rattlesnake who helped provide a couple of the cameras and tripods for tonight. I also want to thank our crew. So I don't know if they'll be willing to step in front of the camera and acknowledge themselves, but I'm going to call them out by name anyway. Way in the back there, maybe she's on the well cam, I don't know, but is Lauren Fitzgerald. She helped operate one of our cameras. Yep, there she is, way in the back. Next to her is Haley Degnan, our mic operator. Thank you, Haley. Over on our left camera here, we have Bridget Sennett. I don't know if she'll turn the camera around so we can see her. There we go, cut to that cam. Hang on, they didn't cut to the cam yet. Keep it. There we go. Can we cut to that camera? There, almost. Well, we saw her for a second. All right, thank you. And then over on the right here, I want to make sure we get a camera on them. Caitlin, maybe you can turn the camera around. I want to thank Caitlin Degnan. Caitlin's been monitoring the Zoom all night. There she is, to make sure everything's going well. And I want to thank, huge amount of thanks to our director for the evening, Abby Militich. It's not easy to operate 6 different camera angles, especially when I'm the one trying to give you the in-service on how to do it. But well done. Thank you, Caitlin. Thank you, Abby. We could not have done this night without you. Seriously, this took it from like, oh, let's put a camera up somewhere to let's make it a production. So thank you both. Very well done. Tons of gratitude to all of you. Okay, let's see. Moving on, want to again mention for those who came in late, who didn't, or maybe forgot I mentioned it, if you enjoyed what you saw tonight and you're coming to Notre Dame or you've been at Notre Dame but haven't done mock trial, we do have the mock trial basics summer school course that is really cool. Learn all about the basics of mock trial, as the name implies, how to do directs, crosses, objections, all that fun mock trial stuff. You can sign up for that wherever you sign up for Notre Dame summer school classes. And oh, look, my hand slipped. It's right there in the chat for you. How convenient. So you can sign up for that. I look forward to seeing everybody in July. Okay, first, the verdict, then the scores. First, I can tell you that according to our very scientific online poll here, the online audience, by a vote of about 62 to 38%, found Jamie Cobey not guilty. So Jamie Cobey's been acquitted by her peers. But this is a bench trial, so mine's the only opinion that matters. And man, what a case, right? You wonder how they come up with this stuff. Well, I hope it's not real, thank you. My goodness. What are you planning? No, for sake of brevity, I'll keep this short. A lot of compelling evidence on both sides. Does seem weird that a rattlesnake would crawl into a mailbox. Does seem weird that that rattlesnake would not have a rattle, conveniently. That being said, there was evidence that rattlesnakes do shed their tails sometimes by accident, not just from Dr. Clay, but from the box of rattles that were in Jamie Cobey's house. So either Jamie Cobey is a serial snake mutilator, or they do really come off with some frequency. It's a high standard to prove guilt in our criminal justice system. You have to prove guilt beyond a reasonable doubt. Not all doubt, just reasonable doubt. Did Jamie Cobey put the snake in Eric Smith's mailbox? Probably. It seems pretty coincidental that she did, if she didn't. But probably doesn't rise to beyond a reasonable doubt. So even though I think you're guilty, I don't think it beyond a reasonable doubt. So I have to acquit you. But nobody lived next door to her, okay? I can acquit you. I'm not going to be your neighbor. Let's put it like that, okay? So you'll be free to go. Now for the scores, because, yeah, congratulations, you're not going to jail. For the scores, because in mock trial, what doesn't matter is the verdict. What matters is the scores. And if I were to explain to everybody at home how the scoring system works, we'd be here all night. It's a weird system. There's percentages involved. I think you have to take the derivative at one point. It's very freaky. But suffice it to say this, scored by people who do understand the system, their fellow mock trial teammates. Adding all the numbers up, it's relatively close. but the narrow winner on points was the prosecution. So congratulations, you guys win on points. Very nicely done. As a concluding thought, let me simply say this. I mentioned at the beginning that almost all of our performers tonight are mock trial rookies, even those that aren't, basically only in mock trial for a year or two. Most of these performers, I think with the exception of one, have never seen the inside of a courtroom because of COVID. They've only been able to compete virtually. And I can tell you that being in the same room, because I know the scripts, I know there were moments where they went off script and they ad-libbed admirably. I almost got through that sentence, darn it. I can tell you that I think I saw more energy just being in the same room on cross-examination and other things. So my final thought is this. Clearly the future of mock trial at Notre Dame is pretty darn bright because you all did fantastic jobs. You really did. And next year, when we're back in person, knock on wood, when we're back in person in an actual courtroom in Redwood City, I know we're going to take this county by storm. So, very well done to you all. Yes, very well done. Absolutely. And that, I think, concludes our mock trial showcase. Thank you to all who watched all the way through. We will have the recorded version of this up at some point in the future as soon as I get a moment. But otherwise, once again, thank you for coming. This is a brand new thing. I know it wasn't perfect, but we learned a lot and we made it possible. We made it happen. And that's what we do at Notre Dame. We do big things. So anyway, thank you all for coming. Have a wonderful evening out there in Zoom land. Court is dismissed. Boom.